Welcome back to Eye on Agriculture. I'm Britton Rucker. Important legal and regulatory updates for farm businesses. Today we'll cover beneficial ownership information reporting, recent nuisance law developments, partnerships for climate-smart agriculture, and tips for handling IRS audits. Lots to cover here, lots to break down. We're joined now with Roger McEowen, Professor of Agricultural Law and Taxation at Washburn University. Roger, to start, how should farm businesses prepare for BOI reporting to ensure compliance?
Well, good to be with you, Britton. I think one of the most important things is to be aware that this requirement is out there and that it will apply to a lot of smaller farming operations because the exemptions basically only apply if you have 20 employees and report gross receipts of more than $5 million in your tax return. And so if you have any type of filing requirement at the state level, then that's going to trigger another requirement to file at the federal level by the end of this year. And so I won't get into the weeds on this because we don't have time, but if you haven't heard about this, you need to talk to your tax preparer or your attorney and get up to speed on this. Now, it's currently being challenged. This whole requirement is being challenged in the courts, but we don't have a resolution yet finally as to whether it's constitutional. So you need to be aware that it's out there. If you had a filing requirement, if you had to register with the state, this will apply to you, and then you probably do not have an exemption. And so you need to be aware of that. And the penalties are bad if you don't file.
Now, Roger, how can farmers navigate nuisance claims and differentiate those from negligence?
Well, nuisance and negligence are not the same thing. You can be operating your farm completely free of negligence. You have all your state permits, your federal permits, and yet you can still be sued successfully on a nuisance theory. And that's, I think, very important to understand. We had a couple of more recent cases on it, but that's basic ag law, what I call ag law 101. Nuisance and negligence are not the same thing.
Now, what should farmers consider in the climate smart practice field contracts to avoid issues, maximum benefits, things like that?
Well, this whole climate smart agriculture stuff, USDA got a bunch of money out of the Inflation Reduction Act, and they have now entered into partnerships with various types of national commodity organizations that then are lining up with firms that will do the certification work for farmers to make sure that farmers have adopted the government-approved practices, so to speak, to be able to get any tax credits associated with those practices. The problem that I see in reviewing one contract recently was this is all purportedly to reduce carbon. But in that contract recently it said that the credits will be paid or compensation will be paid to the producer regardless of whether there's any real or perceived carbon reduction. And so that kind of, to me at least, kind of throws cold water on this whole thing. Are we really trying to reduce carbon or are we just milking the tax code?
Well, Roger, thanks so much for coming on the program. Everyone stick around. Eye on Ag will be back after.